Let's be absolutely clear about what the Department of Justice just did. They didn't merely oppose an independent monitor for the Epstein files. They took the far more radical position that no court in the United States has the authority to force them to follow a transparency law passed by Congress. That is not an opinion. That is the explicit argument they filed in federal court. And that argument has enormous factual and constitutional implications. First, Congress has full constitutional authority to legislate transparency requirements for federal agencies. Article Y gives Congress the power to oversee federal operations, issue subpoenas, and compel disclosure of federal records. They do this constantly through FOIA, the Presidential Records Act, the Federal Records Act, and dozens of statutory mandates requiring specific document releases. Courts enforce these laws every single year. This is normal governance. So when the DOJ claims that federal courts lack authority to enforce the Epstein Transparency Act, they are not making a technical point. They are telling the courts, this law cannot be enforced. We cannot be compelled, and Congress cannot make us comply. That is unprecedented. Second, their standing argument that members of Congress cannot petition for an independent monitor ignores equally well-established law. Courts routinely recognize standing for members of Congress seeking to enforce statutory mandates, victims' rights advocates when statutes guarantee disclosure, public interest plaintiffs in transparency disputes, requesters harmed by agency non-compliance. If the DOJ's argument is correct, then no one, not a member of Congress, not a victim, not the public, could ever challenge the DOJ's refusal to release the Epstein files. That would make the Epstein Transparency Act a dead letter, a symbolic gesture with zero legal force. And again, this is not theoretical. That is exactly what the DOJ is asserting. Third, this position does not exist in a vacuum. The DOJ has a documented history with the Epstein case. In 2008, DOJ leadership approved a non-prosecution agreement that concealed names, sealed evidence, and violated the Crime Victims' Rights Act. A federal judge later ruled that the DOJ acted unlawfully and in violation of victims' rights. The DOJ has never released the full scope of those communications or decisions. These are documented facts. They matter because they establish a conflict of interest, which is precisely when independent monitors are appointed. Fourth, courts appoint monitors, special masters, and oversight officers all the time, especially in cases involving government conflicts, large troves of sealed or mishandled records, victims' rights, potential agency misconduct. Independent oversight is a routine judicial remedy, not some exotic tool. Finally, consider the implications of the DOJ's argument. If the judiciary cannot compel compliance and Congress cannot compel compliance, then the DOJ is effectively placing itself above both branches, asserting the right to decide unilaterally which laws it will or will not honor. That is not separation of powers. That is not constitutional interpretation. That is executive nullification, and American courts historically reject it. There is a century of precedent firmly establishing courts can force agencies to release records. Courts can enforce transparency mandates. Agencies cannot defy Congress by fiat. No branch of government is allowed to insulate itself from oversight. The DOJ's filing attempts to carve out a zone of total unreviewability around one of the most scrutinized trafficking cases in modern U.S. history, a case where the DOJ's own prior misconduct has already been legally confirmed. That's not speculation. That's not conspiracy. Those are facts on the record. So yes, this filing is more than bureaucratic resistance. It is a test of whether transparency laws actually mean anything, or whether an executive agency can simply declare itself untouchable whenever the subject matter becomes inconvenient, embarrassing, or politically explosive. And that is exactly why this decision matters. Not because of curiosity, because it strikes at the heart of how our government functions, who gets to enforce the law, and whether any agency has the power to bury the truth simply by saying, "You can't make us."